Good morning and welcome to today's webinar. My name is John Piper, founder of Piper Transportation Group. I started my career in trucking operations in 1994 with a large dedicated contract carrier and have spent the last 17 years working with fleets around the country to leverage business processes, best practices, and technology innovation to help clients improve their business and increase profits. The areas we specialize in are risk management, safety, DOT compliance, maintenance, driver retention, and business strategy. I am delighted to have on with me today Dee Davis with National Transportation Consultants. She is an expert in the field of DOT compliance. A few housekeeping items before we get started. We do have a large number of companies tuned in to the webinar. All the phone lines are muted to prevent background noise. Feel free to message me during the webinar via the chat window or email questions to john@pipertransportation.com. It's john@pipertransportation.com. We will have time at the end to answer a few questions. Now I would like to welcome Miss Dee Davis. Thanks, Dee, for joining today.
You're welcome. Good morning, everybody. Hope your week is going good so far. Like John said, my name is Dee Davis. I'm with National Transportation Consultants based in Noblesville, Indiana. We do audit management, outsourcing, training, various things with the trucking industry. My background, as you may have seen from the registration material, I started out with the Indiana State Police as a commercial vehicle enforcement officer. So I was the damn DOT for about 20 years. Part of my duties with the state police is I was an instructor not only for the state of Indiana but also for the National Training Center with FMCSA. So I traveled the country doing instructing and training for enforcement officers in the Federal Motor Carrier Safety Regulations. I have a degree in criminal justice and criminology from Ball State University, and so that combined with my experience on the road, and then now my time, 4.5 years now with NTCI, working with industry, kind of seen all sides and all aspects of the transportation industry. Understand a lot of the frustrations that you have as carriers with roadside enforcement. And so I think that puts me in a good position to deal with and help you with these various issues. What I want to talk about today is preparing for an audit. Audits are those scary words. We think of the IRS, we think of the DOT. We don't think this is going to be a pleasant experience for us. So we want to talk about why they're going to be coming in to do an audit. There's several different reasons why they're going to show up. We're going to talk about what they're looking for, their main focus of an audit and what they're going to dig into, touch base on that, and then we also want to talk about what you can do to get ready the day before and the day after, what we do with the paperwork that they're given and what the results are of our audit. As we go along, feel free to send John questions. Like I said, he's going to be monitoring the chat and the question section, and then we're going to take a few minutes at the end to answer questions as well. So sit back, get that cup of coffee ready, and we'll go ahead and get started. So the first thing we want to talk about is why are they coming into my company in the first place? There's actually two main reasons why they're going to come in to do an audit, and they're actually two different kinds of audits. We're dealing with safety audits, and we're dealing with compliance reviews. If your company has gotten a new DOT number or had a major change in management, or you're actually a new company, in the first 18 months that you're in business, you're automatically required to go through a safety audit. The safety audit program has been in place since 2003. Actually went into effect, I believe, in May of that year. So you're going to go through that safety audit, and they're going to look at things a little differently in a safety audit than they are in a compliance review. A compliance review is oftentimes referred to as a full-blown audit, because with the compliance review, they're going to look at all aspects of your operation. They're also going to be looking at possibly a focused compliance review where there's certain specific things you're going to look at, and then a possibility of a fine, and you're going to have a safety fitness determination at the end of that compliance review. But we'll get into the safety fitness determination a little bit later on.
Hey, Dee,
Sure.
we did field a couple questions in advance of the webinar, and I think one of the questions ties in nicely with this portion of the webinar here is, what type of notification is typically given prior to an audit? Is it by phone or is it sent by mail? And how much time before the audit do you have to prepare?
Excellent question. Usually the run-of-the-mill compliance review is they may contact you probably by phone, possibly in person, but they're going to want to set up a time that's convenient both for the investigating officer and for the company to come in to do that audit. There is the possibility, depending on the reason for the audit, they may just show up on your doorstep and announce that they're there and start going through your files. But 99% of the time, they're going to contact you phone, by mail, and then or email to let you know that they're interested in coming in and setting that up. And usually, like I said, they're for the most part going to try to find a date that works out well for their schedule and for your schedule as well. But it is always possible for the dreaded knock on the door for them to show up. One of the reasons they may just show up unannounced if they're coming in on a complaint. Oftentimes they won't announce that they're coming in, or if you would have what I refer to as a newsworthy event. You have a major crash, major spill of hazardous materials, something that kind of catches their attention. They may actually come in within a couple days to take a look at your company. But generally speaking, that doesn't happen very often. Not that it doesn't happen, but it doesn't happen very often. So in addition to complaints, and when we talk about complaints, I don't want you to think that just anybody can pick up the phone, call the FMCSA office in Washington and say, hey, ABC company, they're all smoking pot and they're running bald tires, and I think you need to go hammer them. And the federal agents all jump up and go running out to hammer that company. Actually, if somebody's going to have a complaint, for them to take action on it, they're going to have some what they refer to as specific and verifiable information. Dates, times, locations, names of drivers, routes, things that they can actually come in and pinpoint when they do an audit, not just a general complaint. So if you have a previous employer that decides they want to make, or a previous employee, I should say, that wants to make trouble for you, if they're going to do that, they're going to have some pretty specific information to do so. Not that it's impossible for that not to happen, for them to come in for those reasons, but they're not just going to be able to call with general complaints and get something going against you. The other two things, and the most common thing that would pull in you for a compliance review or put you on the federal radar, is going to be your CSA score. Once you start getting alerts and you start getting 2 or more alert categories or an alert status in the 7 basics, your chances of getting an audit are going to go up. You're going to get on a list to be monitored. And if those scores continue to stay up or get worse, they're going to probably come in to do a compliance review. So that's why it's important to be monitoring your CSA scores, know where you stand, because I can assure you the federal government is watching those CSA scores, especially if they're getting bad or getting worse. The other thing that can pull in for an audit or get you on the radar would be if your crash rate. The crash rate is how many crashes you have per million miles driven. Anything greater than 1.5 crashes per million miles driven is going to be an unsatisfactory crash rate in the eyes of the federal government, and so that can very well trigger a compliance review. The drawback to the system, as it stands right now, is it counts all crashes, not just crashes that were your fault or crashes that were non-preventable. It looks at all crashes. So crashes where somebody slammed into your truck sitting at a red light, you're waiting for the traffic signal to turn, not your fault, the guy was drunk, that's going to count as a crash towards your crash rate. They don't actually remove non-preventable crashes or crashes that weren't your fault until they would actually establish a crash rate. As crazy as that sounds, that's how the system currently works as far as crash rate calculation. So those are some of the things that can pull them in for the compliance review. Like I said, they'll usually give you a week or two's notice, depending on the situation. Might even be a month, depending on the auditor. But it is possible that they may just show up on your doorstep and say, "Hi, we're with the DOT, and we're here to help." So where do you start? The federal government's called. They've told you that they're going to come in to do an audit, and so we want to take a look at where we're at and get ready for them to come in the door. First thing that's going to happen is once that auditor's made contact with you, they're probably going to send you a list of documentation that they want to see. And this is kind of a wish list. Not every piece of information is going to be in your possession because it may be paperwork that you don't generate or things that you don't haul. So like if they start asking for hazardous material paperwork, shipping papers, training documents, and you don't haul hazardous materials, you wouldn't be expected to have that document available. So the first thing you want to do is when they send you, usually in letter form, the things that they're looking for, we want to make sure we go through that list very carefully, figure out what we have, what we need to put together, and who's going to do that, and to make sure that we've got that information available for when the auditor shows up. The two most important things that you're going to do, because these are things they're going to request from you if you haven't already, is you're going to want to prepare lists of your drivers, your interstate drivers, and your interstate vehicles. If they're a state auditor, they may also look at your intrastate side of the operation if you have one. But generally speaking, for a federal investigator, their enforcement powers are limited to interstate transportation. So for my driver's list, I want to make sure I've got my hire date, I've got my full name, license information for that driver, especially if he's a CDL licensed driver. We want to make sure we've got the CDL license number and the date of birth. One of the reasons for that is they're going to run the license of the CDL licensed drivers and make sure they have a valid license at the time of the audit. Another thing you might consider putting on this list, because they're going to ask for, normally, a list of drivers that you've used in the last 12 months. So it's possible that there would be drivers you've used in the last 12 months that no longer work for you. In that case, I would recommend putting the termination date for that driver on that form. So it lets the investigator know when you would stop to being responsible for collecting information, things for the driver qualification file, things of that nature. Also, you might have, depending on your nature of your operation, if you were, say, a pipeline company, where you have a job and maybe the guy works for you for 6 months, he's terminated, and 3 months later you hire him again for another job, being able to explain those gaps in employment, especially when we get into some of the annual paperwork, you would want to be able to have that termination date. So something that, if you've got that information, I would recommend that as well. For vehicles, got to be a little simpler. Want to make sure we have the year and the make, the gross vehicle weight rating, and the date of purchase. So date of purchase tells us when it went into operation. Gross vehicle weight rating is going to give us a pretty good idea whether a CDL license is required to operate that vehicle or not. One thing you might consider putting on the list, in addition to year and make, is a vehicle description, truck, tractor, trailer. Depending on the experience of the auditor, if you show them a list and it lists a Freightliner and a Great Dane, most experienced investigators are going to know that the Freightliner is a power unit or a truck tractor, and the Great Dane is probably a semi-trailer. But not all these investigators have a lot of experience in the trucking industry. No slam against them, but they might not necessarily know what that vehicle is. Or if it's a specialty piece of equipment, especially trailer, something along those lines, might also include that information. But we want to make sure we review that information they send us. Oftentimes they'll send a form first to fill out in advance, asking about things like our miles for the last 12 months, the annual revenue or the gross income for the most recent 12 months, things of that nature. So we want to make sure we've got that paperwork gone over very carefully, and we've got all that information lined up, and we'll have that ready for the auditor when they come in to take a look at things. So what are they looking for when they come in? Well, obviously they're going to be looking for violations of the regulations. What things have you done in your operation that are not compliant with the Federal Motor Carrier Safety Regulations? But in addition to outright violations, they're going to look for gaps in records. Perfect example would be medical cards. Medical cards are generally good for 2 years. But if I've got a 6-month gap between a medical card expiring and the new medical card being obtained by the driver, I'm going to want to know, did he work in that 6 months? If he worked in that 6 months and he drove, that would be a violation as much as not having the record at all. So they're going to look at not just the records you have, but gaps in those records as far as maintaining those things. Now, when they're looking at violations, and everything to do with audits and safety audits is in Part 385 of the Federal Motor Carrier Safety Regulations. When they're looking at these, looking for these violations, there's 2 kinds of violations in an audit. You have acute violations and you have critical violations. Now, an acute violation would mean any time they find a violation, any occurrence, that's an acute violation, and that's actually going to be a point towards the point system that ends up determining your safety fitness determination. An example of an acute violation would be you have CDL licensed drivers, and you're required to have a random drug and alcohol testing program in place, and you are not doing random drug and alcohol testing. All they have to do is show that you don't have a testing system in place, that one, just that one violation, and that's going to count towards the safety fitness determination. Critical violations, they're not as severe, and they're looking for a pattern of violations. And right now, and for years, the federal government's, their definition of a pattern of violations is basically more than 10% of the files that are checked would have to be in violation for that to be a critical violation. Still a violation if they find it, but it doesn't rise to the level of a critical violation and add points towards that safety fitness determination. Perfect example of a critical violation would be violating the 11-hour rule, the driving hours for a driver on hours of service. If they look at 100 logbook files, and by the logbook files each day, if they looked at 100 days for a driver, and in that 100 days he had violated the 11-hour rule 5 times, that would not rise to 10%, and so that would not be considered a critical violation. It would be a violation, but not a critical one. Now, if they looked at that same 100 files and found 20 violations, 20 days where he had violated the 11-hour rule, well, then now that would be a critical violation. So that's the difference between acute violation and a critical violation. So at the end of the audit, when we talk about the day after, they're going to go through those violations, and you're going to know whether it's an acute, a critical, or just a run-of-the-mill violation, for lack of a better term. And then, of course, safety fitness determination for the compliance review is a big part of that. And like I said, we're going to talk about that towards the end. But there is a different standard when we talk about safety audits. When you go through a safety audit, any of you that have been through those realize there's a different standard. But if you're coming up on a safety audit, it's important to know that a safety audit is actually a pass-fail audit. With the pass-fail, it's under, actually, if you look up 385-321, there are some automatic failure violations. Now, this is not an exhaustive listing. This is just more categories from 385-321. If you have drug and alcohol testing that you're not doing, or you use a driver that's tested positive, don't have minimum insurance on file, using a disqualified driver, using a physically unqualified driver, driver without a CDL, operating out-of-service vehicles, or failing to repair a vehicle that you've been told is out of service, periodic inspection logbooks. These are all things that if you have an instance, any occurrence of these violations, that's going to be an automatic failure of the safety audit. Now, the difference between one of the things between a safety audit and a compliance review is there's no fine involved with a safety audit. What you would have to do is come up with a corrective action plan to submit to the federal government on how you're going to correct these things. Now, you notice driver vehicle inspection reports, the DVIRs. That is the only thing that's a little different of these 16 drop deads. The other 15, any occurrence, would cause you to automatically fail. With DVIRs, you have to have 51% of the files. In other words, over half the drivers have to be missing driver vehicle inspection reports, the report they do at the end of the day, for that actually to be a drop dead. But everything else is going to be an automatic failure for any occurrence that they would find. So a little difference between the safety audit and the compliance review. So let's talk about what they're going to focus on as far as the carrier is concerned. And some of these things are going to be similar to what we just talked about as far as the automatic failures for a safety audit. In a compliance review, if you're a for-hire carrier or you're hauling hazardous materials, you're going to have a Form MCS 90 on file. This is not the accord that you get from your insurance company that shows your amount, but this is a specific form that they're going to look for. They're going to ask to see your accident register. If you haven't had any federally recordable crashes in the last 36 months, you're not required to have a blank accident register on file. But obviously, anything in the last 36 months that would fall under that definition, you would be required to have an accident register. Generally, you do these by year. I've only seen one company that I've ever dealt with that kept a running 36-month accident register. Generally, they just kept them by calendar year, which is fine. Signs and lettering, if you're a small company that the inspector or the investigator might not be very familiar with, it wouldn't be a bad idea to have a picture of one of your tractor trailers or just tractors showing the signs and lettering. If you're a bigger company, a well-known company, and it's probably a good chance they've seen your trucks, that's not going to be too much of an issue. But it never hurts to have that picture that they can take a look at, see that signs and lettering, prove that it's in a contrasting color, and it really meets the only two requirements, which are name of the company and the DOT number. But like I said, on the slide, a picture is worth 1,000 words at that point in time. A couple of things you're going to look at. One's really simple, one's not. Access to the FMCSRs. If you have internet access, you're considered to have access to the Federal Motor Carrier Safety Standards, or safety regulations, because you can access the regulations via the FMCSA's website. Of course, if you have copies of the manuals from different companies that are available, that's going to be counted in your favor as well. They want to make sure you have access to those. So that one is the simple one. The not-so-simple one, as far as carriers are concerned, would be your alcohol and controlled substances testing. Obviously, if you're operating CDL vehicles with CDL drivers, you're going to fall into drug and alcohol testing. So they're going to be looking at your pre-employments, make sure nobody's driven before they've received a negative test, and they're going to cross-reference a lot of paperwork at this point in time. This would be an obvious for your logbooks. Start looking for a logbook for a driver that you've hired in the last 6 months to see if you started driving before you actually got that negative result back. They're going to look at your testing rates. If you've been in a program for more than a year, if you have a third-party consortium, they're going to want to see statistics showing that you're testing at the required rates of 50% for controlled substances and 10% for alcohol. Look at all your other documentation. I've seen some federal investigators that really get in depth when we're talking about controlled substances, so that's something to be aware of. They're definitely going to be taking a look at that. As far as the driver is concerned, there's two main areas that they're going to look at with drivers. First is going to be the driver qualification file. We have to keep that DQ file for the driver for 3 years after they're no longer employed, and then obviously we need to keep that up while they're employed. They're going to be looking for the application that's required to be in the file, previous employment history. If necessary, they've got that previous employment history, and you're required to contact those employers. They're going to look for that documentation. They're going to look for motor vehicle records. Did you run the license when you hired the driver? And then are you running the driver's license annually, part of the annual review and the driver's violation certificate? And obviously they're going to look for medical examiner certificates. Of these violations, the two that are going to be critical, that are going to get you into that 10% or more, are going to be motor vehicle records and medical examiner certificates. Not having an application, not having done the previous employment history, yes, those are going to be violations, but they're not going to affect the safety fitness determination. So if you, in preparing for an audit, if you can only focus on two things in a DQ file, make sure you have a file, but make sure you've got motor vehicle records and medical examiner certificates. If you don't have the annual reviews, like I said, that's going to be a violation, but it's not going to affect your safety fitness determination. So that gives you an idea of what you can focus on as far as getting that paperwork together. Another thing I would like to note when we're talking about driver qualification files, when the investigators come in, if you have a problem employee or you have an employee that's been in a crash or has been put out of service, they're probably going to know exactly who that driver is. When they come in, they're going to pull your profile, and they're going to be able to see what crashes you've had, what inspections you've had, out of service violations, and so they're generally going to, I can just about guarantee you, if you've had a driver in a crash, they're going to want to see his file. They will probably pull some random files as well. They have a sampling chart depending on the size of your company, depends on how many files they're going to look at, but they're going to focus on your guys that they know have had problems on the roadside. So just be aware of that. Again, if you've got a short period of time and you're looking at your files and they're not the shape they need to be in, that's a group of guys you can concentrate on and at least have them ready. Sure.
Hey, this is John. A question came in during the webinar, I guess related specific to driver qualification files. The question is it okay to combine a DQ file and a personnel file?
Actually, I would keep those separate. The federal investigator doesn't need to see anything in the personnel file. He only needs to see what's in the driver qualification file. And to be quite honest, he probably doesn't care. I know when I went in to do audits for the state, I didn't care what his withholding was. I didn't care that he had to have alimony taken out of his check. I didn't care whether he turned down company insurance or not. I wanted to see the specific things for the driver qualification file. So I would highly recommend that you keep the personnel file or your human resources file separate from the driver qualification file. Good question, though. Good question. Still looking at the driver. The other thing you're going to look at for the driver, and this is going to be a big chunk of their time during a compliance review, is going to be looking at hours of service. Obviously, you're required to keep the previous 6 months for logbooks or time records. Time records would be if you have a driver under the 100 or the 150 air mile radius exception. They're going to look at those for violations, the 11 and the 14, the new 30-minute break that's in the regulations, and of course either the 60 or the 70-hour rule, depending on what hour rule your company operates under. The other thing they're going to be looking for, and that you're required to keep, are supporting documents. You have to keep those supporting documents for at least 6 months, and I can guarantee you that at a minimum, even a lazy, ignorant investigator is going to ask you for refuel receipts or com data reports if you're using com data for fuel. That's one of the easy things to look at is the fuel receipts have a time and a date, and that's one of the bare minimums they're going to look at when they're checking for falsification. They may ask for payroll records, may ask for bills of lading, especially if your bills of lading have timestamps for in and out. Toll road receipts, meal receipts, hotel receipts. Again, you're not going to have necessarily all the different types of supporting documents, but the ones that you do have, they're going to be asking for. And so just be prepared for that.
Hey, Dee, we've got quite a few oil field service companies on the webinar today, and one question came in from one of those folks. The question is the oil field exemption taken into consideration when they audit logs?
Absolutely, absolutely. One of the changes that was made in the last year or so on logbooks was that waiting time for the oil field drivers, the specially trained drivers, the specially designed equipment, they now have to note that waiting time or have a separate line on their logbooks. But that's definitely something they're going to look at, and something that it doesn't hurt to remind the investigator that you have drivers that operate under the oil field exception. Same thing with companies that use union drivers. How a driver gets paid isn't also automatically connected to how a driver records his hours of service. So if you have union employees and under the contract, there's the possibility that they get paid for hours that they don't work, like call-out pay, for example. That's a minimum. We call them in. They get a minimum of 4 hours, for example, and the guy only works 2. He would log 2 instead of 4. Well, if an investigator is trying to match up that payroll record to the log, that may look like a discrepancy. So when you're supplying those hours of service records and particular employees, that would be a good time to point out to them those special factors that, yes, this driver qualifies for the oil field exception. He's going to have waiting time. This driver is actually a union employee. There may be some time that he got paid that he doesn't log because that's how the contract's set up. So yeah, there's definitely issues that come up, and they will take that into consideration. But it's not a bad idea to remind them that you've got drivers that fall into those categories. One last thing on the hours of service, critical violations, and everything in hours of service is critical. There are no acute violations in hours of service. The problem is, because the emphasis that FMCSA puts on the hours of service, all critical violations, the points you receive for critical violations are doubled. So for the hours of service category, you're either going to be satisfactory or unsatisfactory. There's no middle ground, the middle ground being conditional. So just bear that in mind. If you have a violation of hours of service, that's automatically going to put you into the unsatisfactory category for that particular factor. Moving right along, the focus on vehicles. Vehicles, the 3 main areas are going to be maintenance files. They want to make sure that you've got a maintenance file for each commercial motor vehicle, that you're maintaining the maintenance due, maintenance done, keeping track of those records, have identifying information. The one that many companies do not have, in my experience, is tire size. It's one of those odd regulations out there. Nobody remembers why they require tire size, but the federal government does. Not too many investigators get real hung up on that one, but I have seen some investigators that have gigged companies for not having tire size, so something that's usually easily obtained, that information, and get that in your file. The other 2 things are going to be driver vehicle inspection reports. Those have to be kept for 90 days. A lot of companies use a driver vehicle inspection report that's on the back of the logbook. So by keeping the logbook for 6 months, they're already getting that 90-day time frame for the driver vehicle inspection report. Then the other thing is going to be the periodic or the annual inspection. If you look it up in the regulations, you won't find annual inspection, you'll find periodic, because that's what the federal government calls it. Everybody else on the planet calls it an annual inspection. For as far as your critical violations, your driver vehicle inspection reports and your periodic inspections are going to be your critical violations as far as maintenance is concerned.
Hey, Dee, another relevant question that came up. We keep maintenance files electronically. Would that pose a problem?
Not at all. That's a very common thing for a company to have a system to track their vehicles and track the records electronically. What you're going to want to be able to do is either print the files out for an investigator or be able to set them up where you can show them the electronic files. I would hesitate to set them up at a computer and let them start wandering through to find things. I would highly recommend having somebody from your staff have a computer set up, if you can get in a conference room where you've got a big screen and be able to project it up there so you can pull up maintenance files and show them that information. That's going to be a good way to handle that. So yeah, it's not uncommon at all for those to be kept electronically, and that's not a problem. You just want to be able to produce that information for that inspector.
Excellent.
Most inspectors, when I go into a company, and when I went in as an enforcement officer, I was not real into killing trees, so I was not interested in having you print out 300 pages for 5 trucks. I would much rather have you show me what you've been doing in your electronic system. Yeah, not a problem at all. Not a problem at all. Again, excellent questions. So we know what they're going to be looking for. We know what they're going to look at. Before they come in, we want to make sure that we've got our records put together. We know where our DQ files are. We know we've got our MCS 90, our accident register. We've got all those things laid out, and that we're organized so that when they ask us for it, it doesn't take us 45 minutes to an hour of looking around and making phone calls to find that file. If we're prepared and organized, that's going to be in our interest, or make us look good, if nothing else. We want to make sure that we have a good workspace for the investigator. Electrical outlets, because they're going to have to plug in a computer and a printer. We want to make sure they've got a clear work surface, a desk or a table. Conference rooms work really well if you have one available for an audit. A good, sturdy, comfortable chair. It may be tempting to put the investigator at a card table in the men's room, as one of my former coworkers had happened to him. As fun as that might seem, when just like a roadside officer, the investigator has a lot of leeway, and just like in fishing, if you put him in a card table in the bathroom, he's going to take up all the slack. Probably not going to give you any grace on anything. So as much as you may hate the government and think they're harassing you, but to come in and do this DOT audit, now is not the time and place to take up with that. Find them a decent workspace, get them set up. If the facilities are such that you don't have anything much better than the men's room with the card table, that's okay. I've done an audit sitting at a card table on a milk can in a barn with a cow looking over my shoulder and rutabagas on my left with an Amish farmer. And he wasn't messing with me. That was just the best thing he had available for me to do the audit. And that's going to be pretty obvious to the officer or the investigator when they come in. We're just looking for a good, comfortable workspace, as good as we can put together for them. I get asked a lot of times, should we bring in fruit? Should we bring in cookies? Should we have donuts? Of course, we don't want to make any cop jokes with the donuts. I always tell people, if you generally have coffee going, bottled water, things of that nature, have that available. Depending on the investigator, they may or may not accept that. If it's a sealed bottle of water, they may take that. They bring their own coffee with them. Some officers simply will not accept anything from the company because they think that looks bad. Other officers, if you have something, they may very well partake. So just make them aware of what amenities are available to them. If they want a cup of coffee, a bottle of water, don't be offended if they turn it down. Also let them know where the restrooms are. And as odd as this may sound, when we're letting them know where the restrooms are, we want to make sure that we don't ever leave them alone. We want to have somebody with them, and if they need to go somewhere else in the facility, like the restroom, have someone there that can unobtrusively walk them to the bathroom, basically, wait for them to come out, because we don't want them wandering around our facility at this point in time. Which ties in with the day that they're there. The thing that I want to stress the most is the auditor that's coming in, that investigator is not your friend. They may be very friendly. They may ask questions. I was very friendly. And it's not that I was trying to be deceitful or to get you to open up. It was just my personality. But now is not the time to volunteer information. Now is not the time to clear our conscience. We want to answer their questions. Well, they're going to ask us about our operation. We definitely want to tell them about our operation. Again, an example talking about our oil field exception drivers. We want to let them know what we're doing and what we've got going on. But at the same time, we don't want to volunteer anything. And it's human nature to get nervous and start talking a lot. And so if you can have a sidekick with you and somebody in the room that can kick you under the table, give you that sign that you're maybe going a little too far, be aware of that. So answer the questions they ask, but don't volunteer anything. The second thing, and this is probably even more important, is that you listen, because they're going to be going over these regulations. They're, generally speaking, going to do a little training as they go, talking about things that are best practices, kind of what they're looking for, maybe a better way of doing something as far as your filing system. So listen to that. They're going to provide a lot of information. And don't be afraid to ask questions. Now, again, you don't necessarily want to say, we've got this hazardous material in these unsealed containers sitting out back, and it starts smoking every once in a while, and we're not sure what to do about that. That's not the time and the place to get that particular question answered. Hopefully you don't have that and you've dealt with that long before. But don't be afraid to ask questions or for clarification either during the audit or at the closeout. because one of the things they're going to do is they're going to do a closeout and go over what they found. And that might be, again, I'm going to fall back on the oil field exception. Maybe they tell you have a driver is in violation, and you realize, belatedly, that that's one of your oil field exception drivers. That would be the time to point that out to them so they can double-check those files, possibly remove that violation. Better to do it then before that goes into the final report than to try to challenge the final report a month down the line. So answer questions that they ask. Don't volunteer information. Listen, biggie there, and then don't be afraid to ask questions. When they leave and you've got that inspection report, you can still contact them later, but I would hope that anything you have a question on or you didn't understand, that you ask that auditor that question and get clarification. So what do we do after they've walked out the door? Well, we want to make sure we review the report. They're going to review it with us, but we want to go over that report and figure out, what we need to do, what corrections need to be made. Part of that report they're going to give us, generally won't get that day, although most of them will tell you what the result will be. They will send you the results later. It's going to be one of three things. You're going to be satisfactory, you're going to be conditional, or you're going to be unsatisfactory. Satisfactory doesn't mean perfect. It simply means that you may have some violations, but it's not anything serious enough that the government thinks you don't have a safe operation and can't continue to operate without any impact. So, again, you want to review that report because there's probably going to be a couple things in there for you to take a look at. Conditional means that you can still operate, but you've got some things you're going to need to address. This can definitely affect you as far as your insurance carrier, possibly shippers wanting to do business with you because you have a conditional rating. So it's not something you necessarily want, but it's not also the end of the world. Conditional ratings can lead to fines. They don't usually, but there is that possibility. And then last but not least, we have the unsatisfactory. Unsatisfactory is going to result in a fine, I can assure you, and it's going to result in a cease and desist order. Now, again, it's not the end of the world. Oftentimes, you can put corrective action in place and do a request for upgrade before the 60 days expire that the cease and desist order would go into place and get upgraded to a conditional. It's not unusual to do that. It's going to take some work depending on what you're facing, but it's not unusual to be able to get back up to that conditional and not get shut down. But it is a possibility when they come in to do that audit that you would be facing one of those results. I know we covered a lot of ground and we moved relatively quickly. Any questions that might have come up, John, that or anything now that we can deal with?
Yeah, actually, Dee, quite a few more came in, and again, we're right on schedule, folks. I know we allocated 45 minutes for the webinar. We will stick around a few more minutes beyond that. We understand you have a challenging business to run, so for those that need to drop off, we've got about 5 more minutes. Again, I want to thank everyone for joining, and before we get back into the questions, just remind everyone we will be hosting another webinar August 21st at 10 a.m. Central, 11 a.m. Eastern, and I'll send out an invite to that as well. And Dee, I believe on that one you want to focus on driver qualification files, is that correct?
That is correct, sir.
Okay. Well, so we'll send out an invite to that, as well as this webinar is being recorded, and we'll send a link out. I'll try to get it out by the end of this week to everyone in attendance, and again, feel free to send me questions or comments directly at john@pipertransportation.com. So with that, Dee, we do have a couple questions that came in for you, and I guess the first one is there anything specific that triggers the DOT to come in and do an audit?
Like I mentioned earlier, really the things the biggest trigger is going to be your CSA score. Those alert statuses are going to be triggers. Also, the crash rate, and the unfortunate thing with the crash rate is, like I said, they don't remove non-preventable crashes or crashes that aren't your fault. They simply look at all crashes that you're involved in. It's not unusual for a company to have 10 crashes and none of them are their fault, but it drives their crash rate high enough that the federal government comes in to do an audit. And you can't get those crashes removed until they come in to do the audit and establish a crash rate. As crazy as that sounds, that's a weakness to the system. And then, of course, the complaints. Complaints would probably be the least of the three. I only ever went in on one complaint as an officer, and I've only been on the client with one complaint since I've been doing the dark side, as my former colleagues call it, working with industry. So it's not something that happens very often. It's going to be those CSA scores that are really going to be the kicker.
And Dee, another question came in, and you may have covered this earlier as well, but how this comes in from one of the fleets on the call, how do we know if it's a recordable accident?
Oh, excellent question. The easiest way to know whether it's a recordable accident is just remember this phrase: nurse, hearse, or tow. If you have a commercial motor vehicle that's involved in a crash, and anyone involved in the crash has to seek immediate medical attention, they go see a nurse. If anyone in the crash is killed, they're taken away in a hearse. Or if any vehicle involved has disabling damage that requires it to be towed from the scene, that's going to be a federally recordable crash, and that would need to go in your accident register. So nurse, hearse, or tow.
Excellent. Yeah, actually the questions keep coming in. Unfortunately, we won't have time to answer all of them, but another one pretty relevant here. How long does a fleet stay at a conditional rating?
Until the government would come back in to do a compliance review, or the fleet would put in a request for upgrade, they will always stay at conditional. It doesn't go away, it doesn't go up or down until they would come in to do another compliance review, or the carrier would submit a request for upgrade.
Okay. This is real important. I visit a lot of fleets, Dee, and all of them, with the driver shortage and retention challenges, and just the potential government mandate of electronic onboard recorders. There's just so many challenges out there. And here's a pertinent question. As far as the SMS score on the FMCSA portal, if there's something that is flagged, is there a way for the fleet to either dispute it or provide updates to lower that score back to acceptable?
As far as the CSA score, if you have a particular violation that you don't think is correct, you can actually challenge that violation through the data queue system. And if you don't have it's free to set up an account with data queue, and it's just that. It's DATA, the letter Q. And just Google data queue, and you'll find that data queue system. And so you can challenge individual violations. They've actually made a change just recently that if you got a ticket and you go to court and beat the ticket on the violation, that will be looked at as far as dismissing that violation. In the past, states could cheerfully ignore that court decision, and you were stuck with that violation on your profile. The quickest way to get your CSA score down, obviously, is not have any more violations, but to have clean inspections. Because they look at the total number of inspections, miles driven, your exposure, and they compare you to other similar companies with similar exposure. So if you can get clean inspections, that's going to help bring that number down as well.
Again, I want to thank Dee Davis for presenting today. Dee did an excellent job, and Dee and her team there at National Transportation Consultants has, I think, over 300 years experience in helping a diverse group of fleets improve safety. So if there's any additional questions you have directly for Dee or the team there, feel free to reach out to them directly as well as myself. And I guess the final question, Dee, this came in, can you explain the 70 hours rule, 8-day rule before 34 hours of downtime? What if they don't make the 70 hours within 8 days?
Basically the 70 hours is the maximum that they can be driving or on duty on the bottom two lines of the logbook. And that rule's been around and predates the 34-hour reset. So basically what you do is it's a running 8-day total. So if on Monday morning, Monday morning is going to be day 1, and then I'm going to count back the additional 7 days, which is the same reason you have to carry today and the previous 7 days with you when you're driving. And the investigator or the inspector is going to look at all the hours of driving and all the on-duty not driving hours, and that can't exceed 70. Once you hit 70, now you've got to take a break. Now the 34-hour reset basically says you take that 34-hour block of time, 2 blocks of 1 to 5 a.m., basically 2 overnights in there, of off-duty or sleeper berth, continuous and uninterrupted, and that will reset that 70-hour rule. If I only have 65 hours when I get there, that's not a problem. If I can't get a 34-hour reset, then I'm going to have to watch how many hours I work, because each day I pick up a new day, I drop off a day. So if when I go to Tuesday, now I'm counting Tuesday and 7 days back from Tuesday, instead of, it doesn't keep adding days. So it's always that 8-day window that you're looking at. Does that answer the question?
Yeah, Dee, that was great. Well, with that, folks, again, Dee and I want to thank everyone for joining us today. We wish you to make it a very safe day out there and continue to reach out to your driver staff to improve. Constant, never-ending improvement is what we all strive for. And with that, that will conclude today's webinar. Thanks again.